Maybe we should use this as an opportunity to kick him out.
Yes.
Like a boy band behind closed doors. We say, you're out of here. We've had a meeting. Welcome back to Tort Talk. I'm Mark Ryu, and if you thought the mass tort world was taking a breather in 2026, think again. We are hitting the ground running today with a massive $8.5 million verdict against Uber, a brand new MDL for Lyft, the social media trial everyone's been waiting for, plus a shocking disqualification in the Talc litigation. Joe, let's dive into the headlines shaking up this week.
Yeah, Mark, like you said, really busy week. Everybody's talking mostly about that huge verdict from Uber. So
what happened? $8.5 million.
Yeah, good result, right? The plaintiffs, we were seeking a lot more, but
a whole lot more.
Anytime you can hold a company like Uber liable, it's a victory. So in this case, it went to trial in the MDL. The court had the case. It was actually held in Arizona, and the jury came back after about a 3-week trial with this $8.5 million verdict. But what's really important about this is that the jury found that the driver was an agent of Uber. So they're no longer believing that independent contractor argument that Uber's been making for years and years, not just in this case, but you also see those other car accident Uber cases where they always allege the driver was an independent contractor. So that was a huge precedent. But I will be honest and have to share with everybody, the jury didn't find that Uber was negligent in its safety reviews or basically the design of the platform, but instead found that somebody could believe that the driver was one of their agents. And because of that, Uber's responsible for this verdict. So we still really haven't gotten to the point after 2 trials where they're finding a connection between Uber's negligence and the injuries to the plaintiffs. So there's still work to do, but this is a huge victory. The next trials in the MDL's teed up to start in April in a couple months. So we'll learn from this trial, keep the momentum going, and hopefully have another good result in April.
Yeah, and for the verdict for 8.5, were there any punitive damages in there or none?
Right. So this verdict, no punitive damages. So, right, punitive damages are used to kind of punish the defendant for their willful or reckless conduct. No punitives awarded in this specific case.
If you've been sitting on the sidelines of mass torts because you just don't know where to start, the cost, the lead quality, the complexity, we need to talk. And if you're already in the game and you just want a partner you can trust, we really need to talk. At Our Digital, we're engineered for performance and built to scale your docket. Go to ourdigitalmedia.com to get started. Stop guessing and start growing. Moving on to something very close to Uber, Lyft sex abuse. We talked last week about the motion pending before the JPML for consolidation. The panel granted the plaintiff's motion, and these cases are headed to the Northern District of California. What should we expect to see over the next few months?
Like you mentioned, Mark, this was one of the 2 mass tort cases we were waiting to hear from the panel. It's good news. First panel of the year, we already have 2 new MDLs formed. In this Lyft case, it's going to a great venue, the Northern District of California. That's where the Uber MDL is also pending in California. So we have an experienced court. We kind of have the playbook already laid out from Uber in this litigation. So I expect Lyft to move much quicker. We'll see a lot of the same players from the plaintiff side. I think that these cases will move a lot quicker towards trial. So I'm hoping before 27, we'll end up having our first trial in the Lyft litigation. And so 2 years from inception to trial in an MDL in a mass tort, unheard of. But with this roadmap already laid by Uber, hopefully we'll be able to get there. And then more importantly, enact some changes with Uber and Lyft and how they're vetting their drivers.
Yeah, I bet you Lyft is watching this Uber MDL very closely now.
I'm sure they are, just like the rest of us.
Moving on, social media addiction. The trial of the year is underway with opening statements concluded. What are some of the main arguments that the plaintiffs and defendants are making in this trial? Fun fact before you answer, our co-host, John Robinson, is actually in LA at the trial as we speak.
As you mentioned, this is the trial of the year. Everybody's excited to see what happens here. We have one of the best plaintiff trial lawyers, Mark Lanier. He's leading the charge, and we got to hear his opening statement. And basically what he's saying is that these huge tech companies, we have Meta and Google left standing, they knew their products were dangerous and they didn't do anything about it. Not only that, they specifically designed the products and the algorithm so people could become addicted, specifically targeted targeting the children. What's going on in this case is the defendants, they're following the big pharma playbook exactly as we expect, blame the plaintiff, say it was the plaintiff's problems, the parents didn't do enough, and then also dispute the science. So they're saying the science is unsettled, really, whether or not these platforms can cause addictions. And they're also highlighting in this specific case, although the plaintiff did treat with a number of providers, none of them have diagnosed the plaintiff with social media addiction. So even though the providers acknowledge that it can cause addiction, none of them have specifically diagnosed her according to the defendants. We'll see how that all shakes out over the next couple of weeks. Really excited to hear from John live from California with an update. We should have a verdict, the judge is hoping, by the end of the month.
I can't wait to see what happens with this one. It's like the big tobacco litigation of my generation.
It's going to be huge. There's a lot more cases pending, like you know, but if we get a good verdict in this case, which everybody's optimistic for, this case is going to take off.
Moving on, we got some shocking news in the talcum powder litigation. There's a decision that came down from the New Jersey Appellate Division granting J&J's request to have the law firm of Beasley Allen disqualified from this litigation. You got some inside scoop on this? What's everyone saying on the streets here, Joe?
Yeah, this was stunning. We rarely ever see this. There's been bad blood, obviously, brewing between J&J and Beasley Allen. That's been leading or one of the main firms in both New Jersey state court action and in the MDL. But briefly, what happened was J&J moved to disqualify Beasley Allen because an attorney who used to represent J&J during the bankruptcy structuring and going over the strategy for that retired from the practice of law, started a new company called Legacy, and basically ended up, according to the defendants, working with Beasley Allen to try to come up with a settlement matrix and a way to resolve these cases outside of the bankruptcy. And so they said, J&J alleged that this prior attorney violated ethical rules, even though he had retired. Beasley Allen should have known and shouldn't have worked with him together to get this information on insight on evaluation of the cases, the settlement matrix, things of that nature. So originally their request to disqualify Beasley Allen was denied. They appealed it up to the higher court in New Jersey, and that ruling just came down and disqualified Beasley Allen from about 3,600 cases in New Jersey State Court.
Ooh.
We're going to see how it pays out in the MDL, where there's a similar motion ongoing.
Not a good day at Beasley Allen.
No, not a good day at Beasley Allen, and not a good day for the plaintiff bar either. I mean, this bad blood between J&J and the attorneys, representing them, they've invested so much in this case, so much time, so much effort for these plaintiffs who, again, were hurt by this product that they knew for decades could cause cancer. So it seems a little bit misguided from J&J to be focusing on Beasley Allen instead of trying to get these cases resolved. So I'm sure Beasley Allen's going to appeal this decision up. We'll see what happens, but we, just like Beasley Allen, wants to keep the focus on the injured plaintiffs and get all of these cases resolved.
Are you putting your name into the hat there for leadership, Joe Fantini, as the new replacement?
No, they already have, a good bracket of leadership there. There's a lot of people on the bench that can help out, but we have a trial going on right now in Philadelphia Court of Common Pleas. So that's another talc powder. We're not quite on verdict watch. I think we could be last week. I checked the docket earlier this week. They're going over some potential jury instructions. So could be a huge number coming out of Philly next week. And talc putting more pressures on J&J to do the right thing and resolve this litigation.
Oh, wow, Joe. These are incredible updates. Compared to 2025, I feel like 2026 is just starting off with a bang. Every week there's new updates.
Yeah, it's really exciting time in mass torts. A lot of momentum, hoping to keep the positive vibes going, getting some good news for our clients out of these next two trials we're watching here. Should be some big numbers for some very deserving clients.
Everyone, thank you for watching. Make sure that you like and subscribe if you don't miss any episodes. We release this every week, giving you the updates in mass torts. And then in the comments below, let me know what you think about the Beasley Allen decision. Was it justified? Was it not justified? Looking forward to hearing from you. Joe, thank you again for another incredible week of Tort Talk.